from ratified list for judgment item 1 second appeal 37 of 2021.
Both the substantial questions of law are answered in favor of the respondents. Appeal stands dismissed.
Password case from supplementary list item 4 first appeal 15 of 2025.
Place the judgment first.
The contents of the plaint and the written statement has been rightly recorded in the judgment. The contents of the plaint and the written statement has been rightly recorded
Yes.
in the judgment. You
Yes.
can take it from there.
Yes.
Then. Yes, please.
The present suit has been filed by plaintiffs against the defendants for declaration of title partition in means and bounds and for the permanent injunction suit valued of rupees 80,000.
Please write it.
I'm sorry.
The case of the plaintiff as mentioned in plaint is that the parties, that is plaintiffs and defendants, are Muhammadan and governed by Sunni section of Muslim law. The deceased S.K. Abdul Ghani was common ancestors of plaintiffs and principal defendant number 1 and defendant number 2 to 6 and pro forma defendant number 7 to 11. That S.K. Abdul Ghani, the common ancestors of the parties, predeceased his wife Fatima Khatun, also deceased, leaving behind their 4 sons, Muhammad Alam, plaintiff number 1, Moid Alam, Wali Alam, and Zafar Alam, and 5 daughters, namely Noor Jahan Khatun, Karima Khatun, Zobin Nisa, Safia Khatun, Razia Khatun, since deceased. As their legal.
So just a moment. Karima Khatun is defendant number 6, and so far as this lady Zabul Khatun, Nisha, and Safia Khatun and Razia Khatun. They are not parties. 2 of them have deceased, and Zabu Nisha.
Let
Nisha
me
was
clarify
not-
because I argued the matter before the trial court also.
Why is she not?
There are 4 sons and 5 daughters. One of the daughters, that is Safia Khatun, predeceased the parents.
That's right.
So she was out
Yes.
as per the Muslim law.
Yes.
And one of the daughters' legal years were on record. So 4 sons and 4 daughters, all these legal years were part of the memo of parties. That will be clarified later.
Okay. Continue.
Their legal heirs and successors with respect to their all movable and immovable properties and state of the said deceased. S.K. Abdul Ghani. That Zafar Alam expired, leaving behind his 2 sons, namely Hassan Rizvi, alias Munna, Jahangir Alam, and 1 daughter Ishrat Jahan, and widow Amina Khatun, as the legal heirs and successors. That as the Safia Khatun predeceased to her father S.K. Abdul Ghani, hence she has been disowned and abolished from her rights of inheritance with respect to the state or properties of her father S.K. Abdul Ghani as per Muslim law and Shariat, and hence her heirs who are not entitled for any share over the properties of S.K. Abdul Ghani has not been made parties to the suit. Razia Khatun and her husband also expired, leaving behind their 3 sons, namely Farooq Azam, Siddiqui Akbar, Ali Akbar, as the legal heirs and successor, and the details of the inheritance has been detailed in an analytical table under set out in Schedule A herein below. The common ancestors of the parties deceased S.K. Abdul Ghani, along with Sayyid Muhammad Ikram Ahmad, son of Sayyid Zahiruddin Manizurul Haq, son of late Manizurul Haq, and S.K. Abdul Bari, son of S.K. Muhammad Fakir Ahdan, during their lifetime, was purchased jointly all the piece and parcel of land area measuring 6 bighas situated in Moja Manglo PS Mango under old survey Thana number 15, present Thana number 1641, old Hayward number 3, old Khatian number 4, old plot number 5, district registry office at Chaibasa, presently district sub registrar office Jamshedpur, district Singhbum, presently district Singhbum East, from their own joint money and fund by means of a registered deed number 3877 dated 4/11/1952. Registered at district sub-registry office at Jamshedpur, and since after the purchase of the above land they have been in joint peaceful possession over the same and had been enjoying their all acts of joint right, title and interest and possession over the same during their lifetime without any let or hindrance from any corner whatsoever. That thereafter the said Abdul Ghani, Sayyid Muhammad Ikram Ahmad, Manajrul Haq and S.K. Abdul Bari mutually and amicably partitioned their above land by means of deed of partition dated 5/1/1953 and portion and share of Schedule D, land area measuring 1.5 bighas of said deed of partition dated 5/1/1953 has come in exclusive share and portion of the deceased S.K. Abdul Ghani, who during his lifetime had been the absolute and lawful owner in possession of his above land, and by constructing Pakka house over the eastern portion of his above land had been enjoying its all acts of ownership with his all legal right, title, interest and possession, and had been paying its electricity and other charges in his name to the concerned authority. That in service settlement of the year 1964, the said plot number 5 of the above land converted to plot number 810, 811, 817, 818 and 829, and thereafter in the service settlement of the year 1972, published on 10th day of August 1979, the share and portion of the land of 1.5 bigha land had been covered to plot number 2913, Khata number 763 of Nauza Mango to PS Mango under Thana number 1641, Ward number 9, MNAC, District Sub-Registry Office, Town Jamshedpur, District East Singhbum, which is more fully detailed in this Schedule B, herein below, and which is the subject matter of partition of the suit property and which is within the jurisdiction of the learned court. That S.K. Abdul Ghani, the common ancestor of the parties of the suit, expired on 20th March 1981, and his wife, Bibi Fatima Khatun, also expired in the year 1997. After the death of Abdul Ghani, all parties, that is plaintiffs, principal defendants and pro forma defendants, have jointly inherited, acquired and possessed the Schedule B property, Schedule B below property of the deceased S.K. Abdul Ghani, and have been in joint peaceful possession over the same, and have been jointly enjoying their all acts of ownership, jointly over their respective undivided shares and portion, with their all legal rights, titles, interests and possessions over the same, without any let or hindrance from any corner, and with the knowledge of all concerned. That the plaintiff number 1, having his 2/12 share, and plaintiff number 2 having 2/12 share, and plaintiff number 3 along with pro forma defendant number 9, 10, 11 having their joint 2/12 share and portion over the Schedule B below property as per Muslim law and Sharia.
One thing, I was not able to calculate this 2/12 share, which you need to explain. I was not able to figure out. Continue.
That there are unity and joint possession of parties to the suit over the Schedule B property, and all the parties to this suit are having their respective undivided share and portion over the Schedule B suit property as per Muslim law and Sharia, and which has still not been partitioned in between the parties to the suit.
May I just explain that one? I'll then explain that one so that Lordship can understand while reading this. As per the Muslim law, the division between the sons and daughters are in the ratio of 2:1. So 4 sons and 4 daughters, 4 into 2, 8 and 4 daughter 12. So the sons will be doubled, 2:1 ratio,
Okay.
and daughters will get 1 share.
Simple. So total
So
will be
4
12.
into 2, 8
8
plus 4, 12. So out of 12, 2 shares will be for each sons and 1 share for the daughters. So generally when we calculate, we double the number of sons
Okay.
and add the number of daughters.
That's right.
That's why this 12 has come. That's only to
2
clarify.
by 12. Just a moment. Plaintiff number 1 will get 2 by 12. That will be one share, practically.
1/6,
1/6.
1/6, 1/6, 1/6.
Is there any descendant of any son as a defendant?
Yes, some. That's why Lordship may see at this last week,
The decree does not give any share to any of the defendants.
because it's a preliminary decree. It's a preliminary decree.
Preliminary decree would also declare some share in the hand of the defendant.
Yes, if Lordship could see, the plaintiffs who are the respondents here
Yes.
are basically some of the plaintiff and some of the defendants were the sons and daughters of the deceased Abdul Ghani.
You just see the operative portion. Plaintiffs are entitled to get 6/12, that is half share of the suit property.
6 to if
This is
Lordship
what-
is reading the decree.
No, the judgment final operative portion, page number 61, page 45.
The last one. The suit, as we say, without cause, plaintiffs are entitled to get 6/12, that is 1/12 half share of the suit. Let the preliminary decree be drawn accordingly. So therefore, this plaintiff, who are the respondents here, was the contesting respondents were the plaintiff there. So in Muslim law, the shares is ascertained the day a person dies. So the share of the plaintiff happened stated therein. So the moment the share of the plaintiff stated therein, the rest of the share will be accordingly to other legal heirs of Abdul Ghani. It will be there.
But their portion has not been declared.
That has not been there, but that will be basically what exactly would be, because it is pending for the final decree. The final decree,
That declaration ought to have been here, isn't it?
that will be in my help. Will Lordship clarifies that.
Yeah. That
will
should be there because the share of the respective parties are to be declared by the
It
court.
will be like that. Each son of Ghani
That's right.
will get 2/12.
That's right.
Each
And
daughter or
will
the
get
legal
this.
heirs will get this. But the
That-
problem was that some of the daughters, basically the families of the appellant and family of some of the daughters are intermarried. So 2 daughters supported them regarding the hiba, and the 2 daughters supported us out of the 4 daughters or their legal heirs. So that is, and it was the suit for the plaintiff, so only the decree was passed with respect to that. That was the reason. But the consequence will be that the shares will be like this. I think that will be clarified in the final decree, or if the Lordship clarifies, that will be fine.
Yes, continue please.
Where the principal defendant number 1 is in occupation of Schedule B suit property, who has been allowed by the other parties to the suit to take in use an occupation of Schedule B suit property, but when it has become inconvenient to the plaintiff and pro forma defendants, the plaintiff since last 1 year have been regularly approaching the defendants, particularly the principal defendant number 1, for the portion and demarcation of their respective share and portion over the Schedule B suit property. But principal defendant number 1 took time by some other pretext and did not agree to partition and to demarcate the share and portion of the plaintiffs over the Schedule B suit property as per Muslim law and Sharia. That in the month of May 2014, when it has been learned to the plaintiffs that the principal defendant number 1 has entered into development agreement with respect to entire land of Schedule B suit land and allowed the developer to do the construction work over the entire land of the Schedule B suit property, then plaintiffs inquired into the matter and became surprised and astonished to learn that the principal defendant number 1 fraudulently and mischievously, by using some forged and manufactured documents, could able to get recorded the entire Schedule B suit land in his name in the right of records of the government of Jharkhand. On the basis of some false and manufactured documents entered into development agreement with respect of Schedule B suit land, which is illegal and unlawful, which causes a cloud over the title of the plaintiffs over the Schedule B suit property. Hence, the suit for the declaration of title and partition by means and bounds. That as the principal defendant number 1, on the basis of some false, fabricated and manufactured documents, which he created with a malefic and bad intention to grab the share and portion of the plaintiffs over the suit property, has wrongfully and illegally, on the basis of the illegal and forged and fabricated documents, have entered into a development agreement with the developer.
This is all about cause of action. This is nothing to do with the exact share and what would be the share. And in the middle of the next page, it says that the plaintiff has got no alternative but to file a suit for declaration of total 6 by 12 share in Schedule B. And the genealogy is given over here on right hand side. The entire relief is quoted. Genealogy is given. Is there any dispute regarding genealogy?
No.
There is no dispute. Now let's have a look at it.
One of the contextual addition, that one daughter which they are saying has been predeceased, Abdul Ghani, that has been disputed in the evidence.
We'll see that. Safia.
It
Safia
was-
Khatun.
Yes.
Date of death is not there, but she is one of the
That has been
legal
disputed
heirs.
by the
One of the evidence
appellants.
in one of the this appellant's witness has admitted that I'll show everything.
That's it. How many children of Fatima Khatun? 1, 2, 3, 4, 5, 6, 7, 8, 9 persons are there. But Safia was excluded,
Yes.
right? Therefore, there were altogether 8 persons, 4 sons and 4 daughters, and then you have shown the division. Son,
Shall continue with
And many expired during the pendency of
yeah, that is separate. But this is how it is. And they were duly substituted. There is no
Yes.
dispute on that.
always substituted, and one which was substituted not brought on record in the plain that lordship has done by the orders of this honorable court, in which that 31 legal heir who had already died, whose legal heirs were brought on record by the order,
Yes.
but were not carried out in the plain,
And
which
that
it-
we have taken.
that has been taken care.
Yes.
Shall resume from defendant's case.
Yes. Now we can
Page
come
number
to the
10.
defendant's case. It was ex parte against some of the defendants.
They were pro forma defendants.
They were pro forma.
The contesting defendants are the appellants.
Alright. What was the case of the defendant? Kindly.
Defendant case, principal defendant number 1 in his written statement submitted that the suit is not maintainable in the present form and for the relief claim. There is no cause of action or right to bring the suit. The suit is barred by limitations, estoppel, waiver and acquiescence under the provisions of Specific Relief Act and CPC. That the suit is also barred under the provisions of Mohammedan Law and Partition Act. The plaint has not been properly signed, verified and affidavitated as required under the law, and on the score alone the suit is liable to be dismissed. It is further submitted that the suit is barred for non-joinder and misjoinder of necessary parties. The widow of late Zafar Alam and sons and daughters of Safia Khatun are necessary parties in the suit, and in their absence the suit cannot be proceeded as is liable to be dismissed.
I can understand sons and daughters of Safia Khatun. What about widow of late Zafar Alam? I
That
think she
has-
was made party.
Yes,
That
that
is
was
not
brought on
findings.
record.
So that doesn't survive.
Yes.
What survives is the sons and daughters of Safia
Safia.
Khatun, whether they were necessary parties to the suit. Right? Continue.
She has been claimed to predecease her father.
We'll see that. And
The table as given in Schedule A of the plaint is not fully correct. The description of the suit land as given in the Schedule B of the plaint are vague, confusing, and incorrect. The plaintiff have not filed given any comparative map, and without giving a comparative map, the suit land cannot be ascertained. Therefore, on the score also, the suit is liable to be dismissed. That all the statements and allegations made in the plaint are hereby denied, save and except those which are specifically admitted herein. This written statement and the plaintiff are put to strict proof thereof. That regarding the statement made in para 1 of the plaint, it is submitted that the plaintiffs are required to strictly prove the same. That the statement made in para 2 of the plaint is not fully correct, which will be evident from the fact that stated herein after. That statement made in para 3 of the plaint is not fully correct. That regarding statement made in para 4 of the plaint, it is submitted that Zafar Alam died leaving behind his widow, but the widow of Zafar Alam has not been made party in the suit, whereas she is necessary party in the suit, and in her absence the suit cannot proceed, is liable to be dismissed. That the statement made in para 5 of the plaint is incorrect and hereby denied. It is denied that Safia Khatun predeceased her father, S.K. Abdul Ghani, hence has been abolished from her rights of inheritance with respect to state or properties of her father, as per Muslim law and Shariat, and hence her heirs who are not entitled for any share over the property of S.K. Abdul Ghani. That as matter of fact, Shafia Khatun died leaving behind 6 sons, namely Javed Akhtar, Parvez Akhtar, Firoz Akhtar, Rashid Akhtar, Shahid Akhtar, and Sajid Akhtar, and a daughter Sama Praveen as her legal heir and successor. The aforesaid legal heirs are necessary parties in this suit.
So there is no dispute that had she predeceased her father, in principle, had she predeceased her father, her legal heirs would not get anything. But the dispute is that she did not predeceased her father,
Indeed.
and she died subsequently, and therefore
Therefore,
on the date of death of her father, some property devolved on her. Right?
That is correct. That if she predeceased,
So at
then there is no point.
At least on principle of law,
Yes.
there is no dispute.
no.
And from evidence, I saw.
But that, as a matter of fact, she died.
The aforesaid legal heirs are necessary.
Yes, please carry on.
The aforesaid legal heirs are necessary parties in this suit, and in their absence, the suit cannot be proceed and is liable to be dismissed. The statement made in para 6 of the plaint are not fully correct. Razia Khatun died leaving behind a daughter, also named Razia Shaheen, but the plaintiff suppressed the name of the aforesaid daughter in the said paragraph. That regarding the statement made in para 7 of the plaint, it is
Pause
submitted.
for a moment. Are we joining issues with regard to Razia Khatun also?
That was only the written statement. They never pressed, they never did evidence, and they were never even challenged in the appeal.
So basically, the point is in relation to Safia Khatun, correct?
That is also not taken in appeal. Appeal means there is no ground.
कोई बात नहीं,
Anyway,
तो बहस कर सकते
The
हैं।
court can get into that, but what I am trying that is not in dispute. They are not taken in appeal. Anyway,
अपील यहाँ बहुत मैकेनिकली बनाते हैं। वैसे भी फर्स्ट appellate court would see everything.
yes,
But I just wanted to know from you, and please let me know whether this Razia's status and her son's status, etc., is a matter of consideration for us. Next, buddy. Continue. That regarding the statement made in para 7.
That regarding the statement made in para 7, the plaint, it is submitted that the table as given in schedule A of the plaint is incorrect, which is evident from the facts stated herein above. The statement made in para 8 and 9 of the plaint are not disputed. The statement made in para 10 of the plaint is not fully correct and confusing. It is denied that the survey settlement of the year 1964, the plot number 5 converted to plot number 810, 811, 817, 818 and 829. Thereafter, the survey settlement of the year 1972 published in the year 1979, the shed and portion of land of 1.5 bigha land has been corrected to plot number 2913 under Khata number 763 of Moja Mango, PS Mango under Thana number 1641, Ward number 9, MNAC, and in the subject matter of partition of the suit property. Further, it has been submitted that, as a matter of fact, the land recorded under CS Khata number 4, CS plot number 5, area measuring 6 bigha, Moza Mando, was jointly purchased by Sayyid Muhammad Ikram Ahmad Nazrul Haq, Sheikh Abdul Bari and Sheikh Abdul Ghani by means of registered deed sale bearing deed number 3877 dated 4/11/1952 from one Naru Ho and came in peaceful possession of the same. So the aforesaid purchaser, while were in joint possession of their aforesaid land measuring 6 bigha by partitioned the said land in the year 1953 among themselves equally, and accordingly S.K. Abdul Ghani, the father of the answering defendant, got 1.5 bigha of land in his share and the said partition, and he became the owner of the said 1.5 bigha of land. That S.K. Abdul Ghani, while was in possession of his 1.5 bigha of land, the survey operation commenced, and in the said survey finally published in 1964, an aforesaid land which was in possession of S.K. Abdul Ghani came to be recorded in plot number 810, 811, 817, 818 in the name of S.K. Abdul Ghani. The aforesaid S.K. Abdul Ghani, the father of the answering defendant, who was in possession of the aforesaid land recorded in plot number 810, 811, 817 and 818, Moza Mando area measuring more or less 1.5 bigha, orally gifted the same in the year 1967 in favor of answering defendant in presence of witnesses. That Abdul Ghani, after the Abdul Ghani, father of the answering defendant, made an unequivocal declaration of his intention of making an oral gift of the said land as donor in presence of the witness in favor of the answering defendant as donee, who expressed his acceptance of gift in presence of witness. The declaration and acceptance of gift was accompanied by delivery of possession of the gift by donor to donee. The answering defendant, the gift became complete in compliance of aforesaid requirement of gift. Since the aforesaid oral gift made by S.K. Abdul Ghani, the answering defendant came in peaceful possession of the aforesaid plot of land, measuring 1.5 viga as absolute owner thereof, and also constructed house in a portion of the aforesaid land. The answering defendant, while in possession of the aforesaid land, the present service settlement operation was commenced, and in or about in 1971, the present service settlement operation, the aforesaid land recorded under Khata number 763, PS plot number 2913, A, B, C, D, and E, ward number 9, MNAC, and the structure standing thereon recorded in the name of the answering defendant, is finally published record of right of the year 1979. Further, it has been submitted that the answering defendant is in peaceful possession of the suit property as absolute owner thereof, and the answering defendant also got his name mutated in the Office of Superior Landlord Void Mutation Case number so and so with respect to the suit land, and is paying rent, municipal charges and other charges in his name to the concerned authority.
Now let's pause here for a moment. This is referring to a gift. You have got the written statement?
Yes, sir.
Please take it. Date.
Written statement of original defendant, your ladyship was substituted. There are two written statements, one filed by the original.
Original was substituted will have to only follow the original. Contesting defendant.
That is to be Lordship, may inform one thing, that this defendant number 1 is the contesting defendant in whose favor it is alleged that the oral gift was given.
Yes.
He died after filing of the written statement. Rightly or wrongly, the trial court allowed the legal heirs of defendant number 1 also to file a written statement, and to my
They
benefit,
tried to improve.
no, they ad verbatim wrote the same.
There is no scope for improvement.
There is no scope. Otherwise, also there would not have been any scope. They could not have done
They
it.
could not have done it.
But to
And
my
they have not even done it.
done it.
So, as I find from the record and also from his written submissions, which I want to confirm, that this written statement filed by the defendants, did it give any date, any
Exact.
time? You see that this is a foundational pleading.
No,
There is no date, no
no date, no
place,
time, only
no
year has
time.
been mentioned.
Only here it is
No
mentioned.
place,
No place mentioned.
no name of witnesses.
No name of witnesses mentioned.
In this chapter. Has
You
come
seen
in.
it? It is not there, correct? And if this gift goes, your case goes.
There is one
Let's
more.
figure it out. This you are as a counsel, you just tell us. If this gift, oral gift,
But subsequent to oral gift, your ladyship, there were certain actions which were taken.
we'll see that. We'll see that.
That
But as
remains
per
there,
the
my case
specific
survives.
case of the written statement of defendant number 1, he claimed exclusive ownership of this property by virtue of this gift.
Indeed.
And this gift was hiba according to Muslim law. It does not require registration. The law is well settled on that. Correct? And the basic ingredients are required to be proved through evidence. Now, neither date, nor time, nor place, nor witnesses have been mentioned in the written statement of the defendant number 1. Further, has it come in the evidence?
Yes, your ladyship. One of the witnesses has
Only
taken the
year
name
has come 67.
of, year has come and the name of witnesses before whom the gift was made, the names have been taken.
So, don't you think that these are foundational pleading which was required to be specifically pleaded? Or during the evidence you will come up with a date and then the name of witnesses. Is it permissible under law?
Date was not even in evidence.
Date
Date-
is not there.
year
Date
is
is
there.
nowhere here.
Year
Only
is
year is there.
And you have come up with the name of 3 witnesses. Correct? Let us see it further. It is not there in the written statement. Anyways, you come up with some evidence so far as name of witnesses are concerned. Have these witnesses been examined?
Information. They have not been examined. Whether they are alive or not, it's not
That
there
is
on-
also, that is also
on
not.
the basis of the records.
So therefore, I find it difficult to sustain your case so far as the story of gift is concerned. So you have to satisfy this court that irrespective of all these missing elements, the gift still stood.
So in my submission, the date is not an element in my submission.
Date is not an element of
There is the declaration, acceptance, and handing of the possession. These are the three elements of a gift. So far, I could study your motion. So, date is not one of the essential elements of gift.
So we like to enlighten ourselves on this as to whether date is an essential element of it. In a case of oral gift, it sounds slightly difficult to accept your proposition.
Actually, I'm going through this submissions of my that also there were three grounds of valid gift. That I cannot find the
Those are
otherwise,
proper grounds.
otherwise,
Date is something which is would be, I think,
I need to-
absolutely relevant, absolutely a very important aspect as to when the gift was done, because then all the evidences will be scrutinized qua that. Suppose one of the witnesses was dead by that time, you do not know.
an oral gift your ladyship which has taken place around 60 years back. So there, that is the difficulty which in this case I am presuming that
Oral
the
gift was in
exact-
favor of defendant number one.
Yes, your ladyship.
He was alive at that relevant point of time, even if it was 70 years back. But during his lifetime, I could have
The
understood
date should have
that
been-
during his lifetime he is saying that there was a gift in his favor. So there was no reason, because at the time of giving the gift, he must be present. Without his presence, the gift could not have been done. Right? Once he is there, he should also be aware as to who were present and when.
His presence is not required, his acceptance is required as per.
Or the acceptance without presence.
Let's
it can be.
Maybe by exclusive possession.
It's not required that for acceptance will have to be present there at the time.
Any
ठीक है, कम से कम ये foundational चीज clear होगी that these are missing from the records. Continue. Then there is mutation.
Yes, sir.
Mutation cases
Mutation,
87, 88.
88. Rulership gift in 1967. Final record of rights published in 1979. Subsequently mutation in 87, 88.
In final records of rights, whose name is it bearing?
Defendant, original defendant number one. In favor of whose? Individual. Exclusively.
That will only substantiate his possession,
Individual.
but not the gift.
Individual.
not the time.
It is not proof of title.
करिए, continue करिए.
That from the facts stated herein above, it is crystal. The answering defendant is the absolute owner of the suit property and is in possession of the same. That the plaintiff or the other legal heirs and successors of Abdul Ghani have no manner of right, title, interest, or possession over the suit property or any portion thereof at any point of time since the aforesaid transfer made in favor of the answering defendant. That statement made in para 11 of the plaint is substantially correct. That is, statement made in para 12 of the plaint are incorrect and are hereby denied. It is denied that after the death of S.K. Abdul Ghani, plaintiff, principal defendant, defendant and pro forma defendants have jointly inherited, acquired and possessed Schedule B property of the deceased S.K. Abdul Ghani and have been in joint peaceful possession over the same and have been jointly enjoying their all acts of ownership jointly over their respective undivided shares and portions with their all legal rights, title, interest and possession over the same without any let or hindrance from any corner and with the knowledge of all concerned. S.K. Abdul Ghani at the time of the death himself did not have any right, title or interest over the suit property. That as submitted above, S.K. Abdul Ghani during his lifetime in the year 1967 orally gifted the suit land to the answering defendant in presence of the witness as stated above, which is also within the knowledge of the plaintiff and other legal heirs and successors of S.K. Abdul Ghani. And since then, the answering defendant came in peaceful possession of the suit land and constructed house in a portion of the suit land and living with his family members. that in the year 1971, the present survey operation commenced, and in the present survey settlement, which is finally published in the year 1979, the suit land is recorded in the name of answering defendant. The answering defendant also got his name mutated in the office of superior landlord as stated above and is paying rent, municipal charges and other charges to the concerned authority. The answering defendant also entered in his name in the record of Mango Notified Area Committee and also paying holding tax with respect of the suit property in his name. That neither the plaintiff nor the either defendants and other heirs of S.K. Abdul Ghani ever raised any objection before the survey authority or in the notified area committee or other authorities claiming any manner of interest over the suit land. Further, it has been submitted that the suit property belonged to the answering defendant and he has perfected right, title, interest and possession over the suit property. The plaintiff or the other defendants.
So he is claiming both through hiba also and through adverse possession also, because he says perfected right, title, interest, possession over the suit.
The lines appear like that, but that is not easy.
Yes, sir. Not adverse possession.
There is no case of adverse possession.
The plaintiff or other defendant had no manner of right, title, interest or possession over the suit property or any portion thereof. Thereof, the claim of the plaintiff that they have been jointly enjoying the acts of ownership jointly does not arise and are all false and spurious story. The statement made in para 13 of the plaint is incorrect and are hereby denied. It is denied that plaintiff number 1 has got 2/12 share, plaintiff number 2 has got 2/12 share, and plaintiff number 3 along with pro forma defendant number 9 and 10 having their joint 2/12 share in the suit property. Neither the plaintiff nor the pro forma defendant got any share in the suit property. That the suit property belongs to the answering defendant and he is in exclusive possession of the suit property as absolute owner thereof. Neither plaintiff nor the pro forma defendants have got any manner of right, title, interest and possession over the suit property, or the plaintiffs have got any right to claim any shares in the suit property. The statement made in para 14 of the plaint are false, incorrect and motivated. The answering defendant is the absolute owner of the possession of the suit property thereof. There is no unity of title and unity of possession over the suit property of the parties does not arise at all, nor the plaintiff have got any right to claim partition of the suit property. That the statement made in para 15 of the plaint are false, incorrect and motivated. It has been falsely stated that the other parties of the suit to take the use and occupation of the suit property to the answering defendant number 1 and that it became inconvenient to the plaintiffs and pro forma defendants. The plaintiffs since last 1 year have been regularly approaching to the defendants, particularly to the principal defendant number 1 for the partition and demarcation of their respective share and partition over the Schedule B property, but principal defendant number 1 took time by some or the other pretext and did not agree to partition and demarcate the share and partition of plaintiff over the suit property as per Muslim law and Sharia. The plaintiff have had no right to approach the partition, nor in fact he never approached for partition. That as submitted above, the plaintiffs are pro forma defendants have no manner of right, title, interest or possession over the suit property or any portion thereof. The suit property exclusively belongs to the answering defendant and he is an absolute owner in possession of the same. Therefore, the plaintiffs or pro forma defendants have no right to claim any share from the answering defendant with respect to the suit property, nor the plaintiffs ever approach the answering defendant for demarcation and partition of the suit property. That the statement made in para 16 of the plaint are false, incorrect, concocted and motivated. It has falsely stated that when the plaintiff learned that the principal defendant number 1 has entered into development agreement with respect to the suit land and allowed the developer to do the construction work over the entire land, then plaintiffs inquired into the matter and became surprised and astonished to learn that the principal defendant number 1 fraudulently and mischievously by using some forged and manufactured document could able to get recorded the entire suit land in his name in the record of right of government of Jharkhand on the basis of some false and manufactured documents and entered into development agreement with respect to the suit land, which is illegal and lawful, which cast a cloud over the title of the plaintiff over the suit property. Therefore, the plaintiffs have filed this suit that it is in light of the facts stated herein above, unless the plaintiffs claim for declaration of title on payment of advertisement court fees and challenging the record of right of the suit land finally published in the year 1971, the suit cannot proceed. Even that claim of the plaintiff has become barred by limitation. The plaintiff's claim is also barred by limitation as the suit for partition has been filed after expiry of more than 30 years from the date of death of Abdul Ghani. The above fact also clearly establishes that plaintiff and pro forma defendants are ousted and the answering defendant in exercise of all acts of possession since 1967 as absolute owner thereof to the knowledge of plaintiff and pro forma defendants that as submitted above, the plaintiff have no manner of right, title and interest and possession over the suit property, nor the plaintiff have any locus standi to file this suit. The suit property belongs to the answering defendant and answering defendant has every right to make new construction over the suit land by demolishing the old structures standing thereof by himself or through the builder and developer, and the plaintiff has no right to restrain the answering defendant from making construction over the suit land or any portion thereof. The old structures have already been demolished and the construction of new building is in progress after getting the building plan duly approved by MNAC. That the statement made in para 17 of the plaint are false, incorrect and motivated, which is evident from the fact stated herein above. The plaintiffs have no right to file the suit, nor the plaintiffs is entitled to relief claimed in the suit, nor the plaintiff have got any right to restrain the answering defendants from making construction over the suit land. The statement made in para 18 of the plaint are false and incorrect and are hereby denied. The plaintiffs have no prima facie case and the balance of convenience is also against the plaintiff. The plaintiffs have no manner of right, title, interest or possession over the suit property. Therefore, the plaintiffs will not suffer any irreparable loss or injury. Regarding the statement made in para 19 of the plaint, it is submitted that the plaintiffs have no right to file the suit nor they are entitled to the relief claimed in the suit. That no cause of action arose against the answering defendant as alleged in para 20 of the plaint. That plaintiffs are not entitled to relief claimed in the suit and the suit is liable to be dismissed with exemplary cost. Defendant number 2 in his written statement has claimed that the suit is not maintainable in law as well as facts. There is no cause of action or right to bring the suit. Further, the suit is barred by limitations, estoppel, waiver, exclusions under the provisions of Specific Relief Acts, CPC, provisions of Mohammedan Law and Partition Act. The suit is barred for non-joinder and misjoinder of necessary party. The suit is submitted the widow of late Zafar Alam and sons of late daughters of Safia Khatun are necessary parties in the suit, and their absence, the suit cannot proceed and is liable to be dismissed. That the plaint has not been properly signed, verified and affidavit as required under the law, and on that score alone the suit is liable to be dismissed. It is further submitted that the genealogical table as given in the schedule A of the plaint is not fully correct. All the statements and allegations made in the plaint are hereby denied, save and except those which are specifically admitted herein in the written statement, and the plaintiffs are put to test proof thereof. That regarding the statement made in para 4 of the plaint, it is submitted that Zafar Alam died leaving behind his two widows, but the widow of Zafar Alam has not been made a party in the suit, whereas she is necessary party in the suit, and in her absence, the suit cannot proceed and liable to be dismissed. The statement made in para 5 of the plaint are denied by the defendant number 2, and the claim that Safia Khatun predeceased her father, S.K. Abdul Ghani, and she has been abolished from her right of inheritance with respect to estate or properties of her father as per Muslim law and Shariat, and hence her heirs who are not entitled.
Defendant has fully supported defendant number 1
Yes,
in every aspect, including the aspect of gift.
yes, sir.
Correct?
That is correct.
Yes, almost copy paste.
And
There is nothing new he has said. All aspects are one and the same. What about 3, 8 and 10?
They supported us.
I'll read it.
Defend number 2 supported defend number 1, and they supported the plaintiff.
It's a short statement you will issue.
Yes, you can read it.
In
In
the
order to
written
say it is one and the same, we still need to read it.
So, statement of defendant number 3, 8 and 10 have claimed that the plaintiff has filed the suit for decree in favor of plaintiffs and against the principal defendant number 1, declaring that the plaintiff are having title and possession over 6/12 share over the Schedule B below property of the claim. For a preliminary decree of the plaintiff, 6/12 share, that is 1/2 share in the Schedule B property of the claim. For the decree of declaration of Schedule B property of the claim has not yet been partitioned by metes and bounds as per Muslim law and Sharia amongst joint owners of the parties to this suit, which has been inherited, acquired, and possessed jointly by the heads of successors of deceased S.K. Abdul Ghani, the parties to the suit, for a decree for appointment of survey, knowing pleader commissioner to prepare a separate takta of the share of the plaintiffs and Schedule B property of the plaintiff. For a decree of final decree for partition of the shares of the plaintiffs on the basis of the pleader commissioner's report. For the decree of demarcation of plaintiffs of share over Schedule B suit property through process of the court. For permanent injunction to restrain the principal defendant number 1 and their person to party not to disturb the peaceful joint position of plaintiff over the Schedule B property, suit property, for a decree for the cost of the suit of any other relief or relief to which plaintiff are found entitled under law and equity. That all the statement made in paragraph 1 to 12 are true and correct, and the statement answering defendant do hereby jointly admitting the same as true and correct. The plaintiffs are entitled for 1/2 share over the Schedule B property of the claim. The claim of the plaintiffs are true and genuine. The plaintiffs are entitled for the decree as sought in the claim.
Just a moment here, defendant number 3, 8 and 10 have stated that the plaintiffs are entitled to half share of the
That's
Schedule B
supported.
property. But it appears that in the plaint they have written that plaintiff has got 2/2, plaintiff number 1 2/2 share, plaintiff number 2 2/2 share, and plaintiff number 3 along with pro forma defendant number 9 and 10 have jointly have 2/2 12 shares. That was the case
Yes,
in the plaint.
What they this 3, 8 and 10 wanted to say that out of the 4 sons,
Yes.
1 son claimed gift,
Yes.
3 sons want partition. So these 3 sons together will have half. 2/12, 2/12, 2/12. So all two will have half. So this is they want to say, but wrongly stated that plaintiff will get. It is the others
3 sons.
3 sons. 2/12, 2/12, 2/12. What is it?
This has been rightly recorded in page number 14.
Yes.
It is denied, although they denied it, that the plaintiff number 1 has got 2/12 share, plaintiff number 2 2/12 share, and plaintiff number 3 along with pro forma defendant number 9 and 10 having their joint 2/2 share in the suit property. This should have been the division. The defendant number 9 and 10 or their legal heirs are representing which respondents over here? You just let us know.
Please.
चलिए आगे पढ़िए.
In their written statement, defendant number 4 and 5 have claimed that the suit filed by the plaintiff is not maintainable in law, as well as for the fact the suit is barred by provisions of Mohammedan law or Partition Act. The suit is obviously barred by limitation. S.K. Abdul Ghani was the owner of 1.5 bigha of land, and the same was recorded in 1964 service settlement operation in the name of S.K. Abdul Ghani in plot number 810, 811, 817, 818, Moja Mango. That S.K. Abdul Ghani, while in possession of the aforesaid land, recorded the said plot number 810, 811, 817, 818, area measuring 1.5 bigha Moja Mango. He orally gifted the said land in the name of defendant number 1, Wali Alam, in presence of witness of defendant number 1. As Dhoni accepted the gift in presence of witness, the gift was accompanied by delivery of possession of the gifted land in presence of the witness. That since the aforesaid oral gifts made by S.K. Abdul Ghani, defendant number 1 came in peaceful possession of the aforesaid plots of the land measuring 1.5 bigha as absolute owner thereof, and also constructed house in the portion of the aforesaid land, and has been exercising all acts of possession over the same. That accordingly, the present survey settlement operation of the aforesaid land came in recorded under Khata number 763, present survey plot number 2913, A, B, C, D, and E, Moja Mango.
He is supporting the defendant number 1.
Defendant.
But at the same time, he also says that the possession was handed over simultaneously in presence of witnesses. Right? It was an oral gift and it was simultaneously handed. Then, what were the issues framed and what issues would be relevant? Genealogy is not in dispute primarily.
One dispute is there.
What dispute?
The daughter
Safia Khatun.
Safia Khatun.
But genealogy is not in dispute. When she died is in dispute. But genealogy is not in dispute.
Because the
otherwise.
Safia Khatun's legal heirs are not mentioned in the So if she is being ousted,
If she is there,
if she is there,
so far as this chart is concerned, it does not appear to be in dispute. But if she was to be made party,
then
or her legal heirs were to be made party, then the situation is different. The one of the point for determination would be as to whether Safia Khatun was a necessary party in this matter, right? And so far as Abdul Ghani's property is concerned, that is also not in dispute.
1.5 years.
His description of property is also not in dispute. Correct? What are these documents? So the points would be Roman 5.
The issue
Roman
which have
5.
been framed here. Is the suit maintainable as framed?
Yes.
As the plaintiff got valid cause of action for the suit? Whether the suit is barred by the limitation? Is the suit barred by principle of stoppable human existence? Whether the suit is barred for non-joinder and misjoinder of necessary parties? Whether the suit is barred under the provisions of Mohammedan law and Partition Act? Whether there is unity of title possession between the plaintiff and defendants with regard to the suit property described in Schedule B of the claim? Whether the plaintiff is entitled to get preliminary decree for partition? If so, to what extent?
So Roman 5 and Roman 7 would be relevant. Correct?
Limitation will also be an issue.
Limitation.
Leadership after 30 years,
They are not seeking setting aside of any document, nor they are seeking setting aside of oral gift. That is not their prayer. Their prayer is it's a joint property.
leadership
therefore
one
it
issue
is
which was never framed but that has been a point of consideration, that the entry made in the Khatiyan was disputed, saying that it seems to be fraudulently done. But this issue, so far as the Khatiyan was never challenged, it was never challenged. But if that is to be seen your leadership, then a limitation act will come because it was made in 1978.
That is only possession.
Possession.
That is
Possession will
only
establish
possession.
one of the conditions of guilty.
That is only one of the conditions of gift. Possession in a property which belongs to your family, one or the other person will remain in possession. Right? And what was the relief prayed for? So there is no relief that this particular entry is incorrect.
No, that has never been.
There is no relief.
It has
So
not been
that
challenged.
that's an evidence of possession. That's it. That's an evidence of
That is their defense basically.
that is an evidence of possession. Possession is not in dispute.
Leadership, then there is one more aspect.
I don't think that the plaintiff has also disputed the possession. Have you
No.
disputed the
No.
possession? You simply
Possession
say it
is-
is in joint
We say
possession.
that we were in joint possession constructively
Yes.
and we allowed you to use it because you were only staying in
That has been
that.
disputed by us. We are saying we have then in exclusive possession.
So
Yes,
the-
yes.
That is
Exclusive
disputed.
possession doesn't mean there is a difference between
By way
physical
of
possession.
gift, the ownership
There is a
of the
difference between physical possession and constructive possession.
When it comes to family property, there has to be a physical possession with one or the other person. There may be persons who are living abroad completely for the last 30 years. Right? So
They
far
don't
as the
necessarily-
physical possession is concerned, it will certainly come whosoever is there and on the spot.
But if my
And not to adverse to us. And that position is not averse and adverse to us.
So no case of adverse possession
No.
has been made up.
It's not a case.
It is not a case.
Nobody's case.
You are claiming through gift,
Gift.
and they are claiming that it is an ancestral property.
Has to be partition.
So no point of limitation as such will come.
Though we have dealt with. Even in written arguments I have dealt with.
Yes, what do you want to? You just say that there is a sufficient oral evidence to support the gift.
one witness, the leadership has taken the name of.
Has the court framed any issue with regard to gift?
No, it was not a specifically issue. That was there.
Gift
That
was
issue
never-
arose.
Whether the gift
That
was
will be
valid.
covered whether I am entitled for possession or not, because that is a defense. If the hiba is valid, then I won't be entitled for partition.
We can
But it was
frame a separate point for determination for that.
It could be.
As to
And
whether
that what the trial court actually did in while deciding the issue number 8, 9 and 10, this issue has been discussed. This point has been discussed. Because I, when argued this matter there, the learned trial judge asked me even that is there any specific issue. So the issue was not there. I said that this issue is implicit in issue number 8, 9 and 10. And that has been discussed at length by the learned trial court. When my learned friend will read, it will be clear.
Let us see what all documents you have produced. Plaintiff has got 3 witnesses, right?
Please.
Amongst them is the plaintiff himself.
PW1
PW1 is the plaintiff. Plaintiff number?
Plaintiff number 1,
He is the plaintiff number.
Shakil Ahmed.
Shakil Ahmed.
Is he also the plaintiff?
Just confirm. He is also one of the parties.
Plaintiff number?
He will be. I'll just check. Plaintiff number क्या था इसमें? वही डाला था।
It's plaintiff number 21.
Plaintiff number 21.
21. Shakil Ahmed.
और तीसरा जो था,
And the third one is
Khalid.
Khalid.
Azaz Hassan.
he is a son of a performer defendant,
Number.
Zebu Nisa, who supported the plaintiff.
Zabu Nisa was defendant number.
Defendant number. In the appeal, you can see Zebu Nisa defendant. Is a defendant number 8 in the suit. The
Son of
son of Zebu Nisa.
defendant number
Eight.
8.
One of the sons.
8-1.
8-1.
8 within bracket.
So all were parties.
All right. So 2 of the plaintiffs and 1 from the pro forma defendant
Supporting the plaintiff.
supporting the plaintiff
Were examined.
were examined. Now there are electricity bills, death certificate. What is the date of death of Abdul Ghani?
1981. The exact date is
81.
20th March 1981. And wife died in 1997.
So these are not in dispute.
Not in
Wife died in 1997.
97. The husband predeceased wife.
The electricity bill has been filed with objection.
Wife in 1997. And the property was recorded exclusively in the name of defendant
Way
number
back in 1952.
75.
In the name of the defendant number 1,
Yes.
in the records for the first time,
1979.
1979. In the survey,
During the lifetime of the
Abdul Ghani.
So therefore,
during the lifetime.
during lifetime of Abdul Ghani, it was recorded in the name of
Defendant number 1, Wali.
defendant number 1. That is in the year 1979.
79.
without any consent or confirmation by the Abdul Ghani. That is nobody's case.
Because once, if I am claiming through gift, once gift has been done, his ownership has been transferred
Ownership gets transferred through
to the donee. By the so
every element of gift you have.
yes, that is the entire case. So during the lifetime, and no objection also filed by any of the plaintiffs or father or mother during their lifetime against the entry made in record of rights.
During lifetime of Abdul Ghani.
Provided
No
they
objection
prove,
still date has been made. against
provided
the-
they prove that we had knowledge of it.
That's right. Then there is an order under section 89 also. That is order of 1975. This is the appellate order, 1989.
Yes, 73 and 75, there are two orders of C and T,
Yes.
which I have relied that the father fought those cases. Abdul Ghani. Had it been a case of 1967 gift, the father would have said that I am no more the owner, one of my son is the owner, so I am not bothered.
So therefore, this entry in record of rights was subject matter of consideration under section 89 of the CET.
Which they have not disputed.
And this particular order was decided in whose favor?
It was the original case was against me. Then I went to the appeal, the father, the grandfather, and he won it.
He won that.
Yes. See,
So therefore,
in both the cases,
so
the father Abdul Ghani was there.
Therefore, entry in record of right in the year 1979 stood nullified by virtue of the order passed under section 89. Let us see exhibit 4. Exhibit 4 देखते.
It will be at pages. I'll just point out that because I have inspected the file. It will be at page 120 and 122 of the record of volume 2, this Roman 2 file.
120. This is case number under section 89. Okay. Abdul Ghani is the party
Yes,
over there.
Abdul Ghani. And divorce all this, if Lordship could see only one page 185. That basically demolishes the entire case, 185, in the same paper book.
Yes.
Lordship, see that 185, when in the mutation, when the column is given, whether the mutation is due to the sale, gift, exchange, succession or partition, the reason is given Khatiyan Parcha ke aadhar pe hai. So they get their names recorded in the survey. On the basis of survey, they got it mutated. They could have said very well here on the basis of oral hiba. So it basically defeated their own case, and it is they filed this document before the trial court. That demolished their entire case.
There is an explanation to that determination.
We'll see that. Now let us see this order exhibit 4. Because there is an order under section 89. Exhibit 4. Exhibit 4 says that the order in case number 328 of 73-74 will govern this case as well as the facts of the two cases are similar. And where is the order of 328 of 73-74?
These were the two documents which were available, and these were exhibited.
Case number 223. Perhaps exhibit 5 only.
4 and 5. Exhibit 4 and 5. 5 is the appellate order, 4 is the original order of the CNT.
Exhibit
4 and 5.
4, Exhibit 4 is order under section 89.
Yes, that was the appellate order.
That was the appellate order, but it says only that the case will be governed by case number 328 or 73-74. But the order of 328 or 73-74 is not on record.
If Lordship could see page 120, that is the order of 1980-75. Lordship has that?
The petition is rejected.
It's prior to entry.
11-8-75.
11-8-75.
This is prior to that.
Yes, it's prior to that. But I am more on that page number 230, which I have shown Lordship as page 185. That was of 79 after this. So when they got mutation, the basis of mutation is different. That is 79. Sorry, not even 79. That is basically of the year. If Lordship could see 30th of 11-87, when the mutation was complete.
Yes.
Order of mutation is at page number 183. That is the order of mutation, 30th 11-87. Along with this order of mutation, Lordship, this is the appendix to that order, which gives the recordings of 30th November 87.
आवेदक स्वयं खतियानी रैयत.
Which was not an incorrect statement, Your Worship, on 1887 and 87. Because in 79 his name was recorded as the Khatiyani.
No,
That
but
is not an
when
incorrect
No,
the
but you
statement.
claim to be the Khatiani Rayyat. That was your claim.
Once my entry has been made in leadership in the Khatiyan, so I become the Khatiyani. on that.
but Lordship could see the
And
choices
subsequent
given.
correction-
What is the
subsequent-
choices given? Choice
That
is
would have taken place, Your Ladyship, if my correction slip would have been drawn before my entry made in Khatiyan.
sale, gift, exchange, succession or partition. They
My
could have written that it is on the basis of oral hiba, and on the basis of oral hiba, my survey was done.
It
So
was
in
not
none of
required
the
in-
official records,
My
this
submission
oral
was
hiba
not
is there.
required. My submission it was not required, Your Ladyship. Because once my entry was made in Khatiyan, subsequent by which means my entry was made was not required to be recorded.
Where is the document by which your entry was made? Where is the order under section 83?
That is at page, Lordship could see.
122.
That not is not one, but that is 183.
183.
Is the order of mutation.
The order of mutation. There is one exhibit P, Your Ladyship. I don't
Exhibit
have P.
P.
Yes, Your Ladyship. That is the certified copy of order dated 9/5/1985, passed by the Assistant Settlement Officer, Jamshedpur, in case number so and so. This order is of 9/5/1985, subsequent to my entry made in Khatiyan. So that order will be recommended. Although I have not examined that order, Your Ladyship, but from the judgment I have seen there is this order. Once my entry was made in 1979, this order is subsequent to that entry. So this order will have a binding
One Bihari Sahkari Samiti
against the forest.
versus Wali Alam.
That is defendant number 1, Your Ladyship, against.
But that will not give the title. That will be on the basis of what records, whose
So
names
I was-
get mentioned.
So otherwise also there is no dispute that in the record of rights your name was included.
Yes, we are not disputing.
This is not in
But we
dispute.
say that you have wrongly
But-
got it done.
But that is, does it amount to
Your
say?
Lordship, saying that that is wrongly done is required to be proved. There are series of judgments of this.
No, let
honorable
us
court.
assume that it was rightly done because they have not challenged that record of rights.
So
They have not challenged that entry in record of
Never,
rights
never.
specifically. They have not filed a suit challenging that particular entry in record of rights. So whatever was the entry in record of rights became final. But does that prove hiba? That is the point. Even if you are in exclusive possession of property, does that prove the gift or not? This is the point. Isn't
From
it?
where you derive your title.
From this, on this point, Your Lordship, I will try to.
Yes, that is why. That is why
try my
we are
senior
here.
to assist.
Yes, you tell your senior that these are the
The-
issues which will come up. Even if the possession is there, even if the entry is assumed to be correct, there is a presumption with regard to entry in record of right. But presumption is only with regard to possession. Presumption is not with regard to title. Isn't it?
So you could see the issue-wise findings.
Yes, we'll see the issue as finding, and that is all for the day. And
Statement
these evidences which have been discussed, you can go through it and let us know that which all are the clinching evidence
We are-
on the point of. चलिए जरा पढ़िए Finding बताइए.
Findings, page number, internal page number, Your Lordship, 32.
32 and there.
Starts with issue number 7.
Yes, issue number 7.
Issue number 7 is the most important issue for determination in this case, which is whether there is unity of title and possession between the plaintiff and defendant with regard to the suit property described in Schedule B of the plaintiff. So this issue is taken up first for discussion. It is not disputed between the parties that S.K. Abdul Ghani was common ancestor of the parties. It is also not disputed between the parties Abdul Ghani died in the year 1981 and his wife Fatima Khatun died in the year 1997, leaving behind their 4 sons and 5 daughters, namely Mahmood Alam, Moin Alam, Wali Alam, Zafar Alam, since deceased, and have five daughters, namely Noor Jahan Khatun, Karima Khatun, Zubin Nisa, Razia Khatun, and Safia Khatun as their legal heirs and successor. It is not disputed between the parties that the common ancestor of the plaintiff and defendant Abdul Ghani, along with Sayyid Muhammad Ikram Ahmad Mazirul Haq and S.K. Abdul Bari, jointly purchased the land measuring 6 biga, bearing old plot number 5, old Khata number 4, old Khewat number 3, Moza Mango, town Jamshedpur, district East Singhbhum, by means of registered deed of sale. Bearing deed number 3877 dated 4/11/1952, registered at Sub-Registration Office Jamshedpur and had been in joint peaceful possession over the aforesaid land without any hindrance from any corner. It is also not disputed between the parties that S.K. Abdul Ghani, Sayyid Muhammad Ikram Ahmad, Mazurul Haq and S.K. Abdul Bari mutually partitioned the above land by deed of partition dated 5/1/1953, and in the said portion, the land area measuring 1.5 biga described in Schedule B below came in exclusive share and partition of deceased Abdul Ghani, and he had been absolute and lawful owner of the possession of his above land. It is also not disputed between the parties that plot number 5 converted to plot number 810, 811, 817, 818, 829 in the year 1964. Survey settlement, and in the survey settlement of 1972 published in 10th day of August 1979, the share of the portion land of 1.5 biga had been converted to plot number 2913 under Khata number 763 Mojan Mango, ward number 9, MNAC. In the plaintiffs have claimed that after the death of S.K. Abdul Ghani, legal heirs and successor of Abdul Ghani, plaintiff and defendants, have jointly inherited and acquired the suit property and have been enjoying peaceful possession over the same and have been jointly enjoying their all acts of ownership over their respective undivided share and portion, with all legal rights, title, interest and possession over the same as per Muslim law and Sharia, and has not yet been partitioned in between the parties. In the plaintiffs have also claimed that principal defendant number 1 Wali Alam had an occupation over the suit property which had been allowed by the other parties to the suit to use and to do occupation over the suit property, but when it has become inconvenient to the plaintiff and the pro forma defendant, the plaintiff since last 1 year have been approaching the plaintiff, principal defendant number 1, for partition and demarcation of their respective shares and shares over the suit property. But principal defendant number 1 took time by some or other pretext and did not agree to partition the same plaintiff over the suit property. Further, in their plaintiff have claimed that in the month of April 2014, when it has learned to the plaintiff that principal defendant number 1 has entered into development agreement with respect to entire suit land and allowed the developers to do the construction work over the entire suit land, then plaintiff inquired into the matter and became surprised and astonished that the principal defendant number 1 fraudulently and mischievously, by using some forged and manufactured documents, recorded the entire suit land in the name and entered into development agreement with respect to the suit land. Whereas in their written statement, contesting defendant has claimed that while the father of the principal defendant number 1 was in possession of the disputed land measuring 1.5 biga, bearing 1964 survey plot number 1810, 810, 811, 817, 818 of the Moja Mango, orally gifted the same in the year 1967.
ये जो आपके WS में नहीं है, 67 is not mentioned in WS.
This part.
67 is not mentioned. Please confirm.
In
Mentioned?
Yes, it is.
67 is not it's mentioned, but date is not.
Date is not. Year is mentioned.
Date, time, month, place, witness.
All right, continue.
In the year 1967, in favor of the original defendant number 1, Wali Alam, in presence of witness, aforesaid Abdul Ghani made an unequivocal declaration in his intention of making an oral gift of the said 1.5 biga of land as donor in presence of the witness in favor of the defendant number 1, Wali Alam, as donee, who expressed his acceptance of gift in presence of witnesses. The declaration of acceptance of gift was accompanied by delivery of possession and land by the donor to the donee. The gift became complete in compliance of the aforesaid requirement of gift. Thereafter, principal defendant number 1, Wali Alam, came in peaceful possession of the aforesaid plot of land measuring 1.5 biga as absolute owner and also constructed house in a portion of aforesaid land.
Further, in their written statement, contesting defendant have claimed that while the defendant number 1 Wali Alam was in possession of the aforesaid land, the present survey settlement was commenced in the year 1971, and in the present survey settlement of operation of aforesaid land gifted by S.K. Abdul Ghani to his son Wali Alam since deceased, recorded under Khata number 763 under survey plot number 2913 A, B, C, D and E, Moja Mango, Ward number 9, Aminasi Mango, and the structure standing thereon in the name of Wali Alam, and finally published record of right of the present survey of the year 1979. Thereafter, Wali Alam got his name mutated in the office of superior landlord in mutation case number so and so with respect of the suit land, and has been paying rent, municipal charges and other charges in his name and concerned authority, and after the death of the principal defendant number 1, legal heir and successor of deceased principal defendant number 1 became the absolute owner of the suit property, and the plaintiff or the other legal heirs of the successor of Abdul Ghani had no manner of right, title, interest or possession over the suit property. In support of their case, plaintiff have filed some document and got exhibit 1 by 1, 3 original electricity bills by which it appears that the aforesaid electricity bills are in the name of Abdul Ghani and issued by the Bihar Electricity Board in the year 1963. This fact is not disputed between the parties. Exhibit number 2 is the death certificate of S.K. Abdul Ghani, by which it appears that the common ancestor of parties Abdul Ghani died on 20th March 1981. This fact is also not disputed by the parties. Exhibit number 3 is the certified copy of the sale deed bearing number 3877 dated 4/11/1952, by which it appears that Abdul Ghani along with Sayyid Muhammad Ikram Ahmad Mazirul Haq and S.K. Abdul Bari had purchased the land area measuring 6 bighas, CS plot number 5, CS Khata number 4, Mango. It is admitted by the parties that Exhibit 4 is the certified copy of the order dated 11/8/1975 passed by Charge Officer Singhum Settlement, Jamshedpur in case number 333-1973-74 under section 89 of CAT Act, by which it appears that the DFO Dalbum Division had filed a case under section 89 of the CAT Act against Abdul Ghani. Exhibit 5 is the certified copy of the order dated 28/8/1973 passed by the Assistant Settlement Officer Jamshedpur in case number 2223/7273 under section 83 of CAT Act, by which it appears that S.K. Abdul Ghani appeared and contested the case, and after perusal of the documents under order being passed in favor of Abdul Ghani, DW3 Waliullah in para 38 of the cross-examination has admitted that in the year 1972-73 a case under CAT Act was filed against Abdul Ghani, and on the case he was contest the case. Thereafter, case number 33374 under section 89 of CAT Act was filed against him. Here in the case, the contesting defendant claimed that the disputed land measuring 1.5 bigha bearing 1964 survey plot number 810, 811, 817 and 818 of Moja Mango, present survey settlement of operation recorded under Khata number 763 plot number 2913 A, B, C, D and E under Moja Mango, Ward number 9 MNAC Mango in the year 1967 orally gifted by Abdul Ghani in favor of principal defendant number 1 Wali Alam since deceased in presence of witness. Aforesaid Abdul Ghani made an unequivocal declaration of his intention of making the oral gift of the said 1.5 bigha of land as donor in presence of witness in favor of the principal defendant number 1 Wali Alam as donee, who expressed his acceptance of gift in presence of witness. The declaration and acceptance of gift was accompanied by delivery of possession of land by the donor to the donee. The gift became complete and compliance of the aforesaid requirement of gift. It is further claimed that contesting defendant, since the aforesaid oral gift made by S.K. Abdul Ghani, the principal defendant number 1, Wali Alam came in peaceful possession of the aforesaid plot of land measuring 1.5 bigha of absolute owner thereof, and also constructed house in portion of aforesaid land. After survey settlement, disputed land recorded in the name of principal defendant number 1 Wali Alam. Thereafter, Wali Alam got his name mutated in the office of superior landlord, mutation case number so and so, with respect of the suit land, and has been paying rent, municipal charges and other charges in his name to the concerned authority, and after the death of the principal defendant number 1, legal heirs or successors of deceased principal defendant number 1 became the absolute owner of the suit property. From perusal of the exhibit F, which is the certified copy of Khatiyan of Khata number 763, by which it appears the aforesaid Khatiyan is recorded in the name of Wali Alam in the year 1979,
Exhibit G is the certified copy of order dated 25/1/1989 passed by LRDC Dagun and Jamshedpur in rent fixation. Case number 137/1988-89, by which it appears that Wali Alam, deceased principal defendant number 1, had filed an application before the LRDC Jamshedpur for rent fixation of the disputed land. Exhibit H is the certified copy of the order dated 30th/11/1987 passed by Anchal Adhikari, Juksalai Kam Gulmuri, Jamshedpur in mutation case number so and so, by which it appears that the disputed land is mutated in the name of Wali Alam. From perusal of the Exhibit 1, 1/1 and 1/2, 3 original rent receipts dated 9/2/1989, 16/9/1994 and 9/6/2014 respectively, by which it appears that rent is being paid in the name of Wali Alam, deceased principal defendant number 1. From perusal of Exhibit J, certified copy of judgment passed in JC2 case number so and so under section 13 of the BRLU, by which it appears that regarding the suit land, a proceeding was initiated against the deceased principal defendant number 1 Wali Alam under BRLU Act, and in said case, deceased Wali Alam was acquitted. Exhibit K and K1, 2 original Panchmali receipts issued by MNAC Jamshedpur, by which it appears that the aforesaid Panchmali receipts was issued in the name of Wali Alam. Exhibit L, original form O issued by MNAC, by which it appears that the said Exhibit L is issued in the name of deceased principal defendant number Wali Alam. Exhibit M, original building permission number 85 dated 30th/11/2014 with respect of the suit holding, by which it appears that the aforesaid building permit was issued in the name of Wali Alam. Exhibit N is the approval of building plan. Exhibit O is the mutation correction slip in mutation case number so and so issued by Anchal Adhikari Jamshedpur, by which it appears that the mutation correction slip in the name of Waliullah, son of late Wali Alam. Exhibit P is the certified copy of the order dated 9/5/1985 passed by the assistant settlement officer Jamshedpur in case number 267/85, by which it appears that the proceeding under section 90 of the CIT Act was initiated by Ban Vibhag, Bihar Sarkar against Wali Alam, deceased principal defendant number 1, with respect to suit land. DW1 Shahullah, who is one son of Wali Alam, in para 51 of the cross examination has admitted that in the year 1972 his father Wali Alam was ward commissioner in Mango Notified Area Committee. It is also admitted position as stated in written statement as well as in the evidence of the defendants that survey settlement was started in 1972, which was finally published in 1979, in which the name of Wali Alam appeared. The contesting defendant also filed Appendix C 28, which is the correction slip dated 30th/11/1987 showing mutation in respect of suit property, which shows as whether the mutation is due to sale, gift, exchange, succession of partition, but it shows as on the basis of Khatiyan Parcha. If the
Is
alleged
this the first correction slip issued? Is this the first one?
Pursuant to entry made in Khatiyan.
This is the first correction.
Yes. Pursuant to entry made.
After quite some time. After 1972.
79, your ladyship, it was
The survey.
survey. My name was there.
Survey was
Khatiyan.
published.
This
And thereafter some proceedings.
drawn, your ladyship, and this correction slip is dated 30th/11/1987.
And meanwhile, there was different proceedings, your ladyship, of one Vibhag and section 90 proceeding.
But you declared that it is on the basis of Khatyani Parcha. It
Yes,
means that you wanted to say that there is already an entry in record of right,
Yes, sir.
and therefore on that basis it was
Had it
done.
been, your ladyship, a situation where the entry was not made in Khatiyan, then in correction slip I would have been required to show how I have acquired that land, which is the primary contention of the plaintiffs.
In order to make an entry in record of right, some proceeding is to be initiated.
Yes, your lordship.
What is
Proceeding
that
is
proceeding?
initiated, your lordship. Survey is done. Possession is verified.
It is regular survey. Suppose you want to have a change in entry in record of right.
It has to be challenged. Your lordship.
Okay, on behalf of the defendants, continue please.
Yes.
If the alleged story of
If the alleged story of oral gift would have been correct, the reason for mutation ought to have been gift and not the basis of Khatiyan. So, in view of the documents of title and possession, the present survey entry in name of Wali Alam seems to be obtained fraudulently. On behalf of the contesting defendants, 4 witnesses have been examined, and out of the 4 witnesses, defendant number 1, Sanaullah, and defendant number DW1 and DW3 Waliullah are the sons of deceased principal defendant number 1 Wali Alam. DW1 Sanaullah in para 43 of his cross examination has stated that the disputed land was gifted by Abdul Ghani. The time he was about 7 to 8 years old, and the gift was given orally. In the first time in his examination in chief, he deposed that Gulzar Ali, Abdul Mati, Tahir Hussain were the witnesses before whom the alleged oral gift was made and accepted. DW1 do not disclose the date, month and place of oral gift. DW2 Sohail Ahmad Sufi in para 10 of the cross examination has stated that he has been living in Dhanbad since 1958 and started coming to Jamshedpur since 1975. Further, in para 12 of the cross examination, he has stated that Waliullah is his relative. Recently, he has become the Samdhi of Waliullah. His daughter is married to Waliullah's son. Further, in para 19 of the cross examination, he deposed that oral gift was made in 1967. At the time, he was just 14 to 15 years. The witness has also did not disclose the date, month, and place of oral gift in the first time of examination. In chief, he deposed that Gulzar Ali, Muhammad Martin, and Tahir Hussain were the witnesses before whom the alleged oral gift was made and accepted. The witness seems to be interested witness. DW4 Naushad Ali in para 17 of his cross examination has stated that in the year 1967 his age was 16 years. He is permanent resident of Jabalpur, Madhya Pradesh, but his birthplace is Sakchi, Jamshedpur. Further, in para 27 of his cross examination, he deposed that it is true that Abdul Ghani gave his house to his son Wali Alam to reside and use for his business. In para 3 and 4 of his examination in chief, he deposed that 1967 disputed land was given to S.K. Abdul Ghani to Wali Alam through oral gift, and at that time Gulzar Ali, Abdul Martin and Tahir Hussain were present. He was also present with his father. None of the alleged 3 witnesses were produced before the court as witness, and it is also not averred that they are not alive or not traceable. None of the 3 defendants' witnesses, DW1, DW3, took the name of Naushad Ali. From perusal of the case record, it appears that while instant suit was filed, then principal defendant number 1, Wali Alam, was alive, who appeared in the suit and filed his written statement on 12/3/2015. And in his written statement, he claimed that Abdul Ghani during his lifetime in the year 1967 orally gifted the suit land to him. Principal defendant number 1, in presence of witness, which is within knowledge of the plaintiffs and other legal heads and successors of said Abdul Ghani, since then he is in peaceful physical position in the suit land. But in the written statement, date, month and place of the oral gift are not mentioned. It is not mentioned as to who were the witnesses before whom the alleged oral gift was made and accepted. None of the legal heirs, sons, daughters of late Abdul Ghani were the witnesses of the alleged oral gift. According to the Mohammedan law, there can be a valid way to
So there are numerous documents to show that you were in possession of it. This is what you notice. Possession of the property after the so-called oral.
which was not interrupted or challenged by any of the
That's
people
it.
at any
They were
point
in
of time.
possession even before the oral gift. They were in possession even before the oral gift. So possession is never
I
in
have
dispute.
been present.
I just want to know, I don't know, you have not raised such a point, but is it permissible under Mohammedan law to give the entire property as gift?
Yes.
Entire property?
Yes. That is the difference between will and gift.
Will cannot
Will
be-
only 1/3.
Will only one.
And there is, because I am handling a case in Delhi, if a hiba is done at the fag end of your life, when you apprehend that you will die soon, then that hiba will be converted into a will. That is called marzul maut, because you are apprehending that you will be dying soon. If somebody was dying, because one of my other side of my client died of cancer and he was hospital in Rajiv Gandhi Cancer Hospital. So I made
At
a.
that point of time,
So he knew that he will not survive. So if he make any gift,
So it has to be a conscious exercise of relinquishing the right.
yes,
Without
that
realizing
you know
that he is
without
soon
any
going to die.
force, pressure, your own violation and will, that you in your own life want to give the entire thing to
So
somebody.
for all practical purposes, last moment gift is
It means there
essentially
is
a
some,
will.
there is
Is
something
essentially
more
a
than
will.
your wish. So that's why it gets converted into a will. Only 1/3 will be
In
applicable.
one case, I am facing this, but I forgot that that is a case of will and not hiba.
Will is 1/3.
Done. Alright. So para 17 are the basic ingredients. Can you read that?
According to Mohammedan law, there can be a valid gift if three essential elements of the gift are satisfied. A declaration of the gift by the donor, the acceptance of the gift expressed or implied by or on behalf of the donee, delivery or possession of the subject of the gift by the donor to the donee as mentioned in section 150. If these conditions are complied with, the gift is complete.
There is no dispute on this.
On the point of oral gift, learned counsel for the contesting defendant had relied upon the decision reported in AIR 2010 SC 211 Abdul Rahman and others versus SK Abdul Zabar and others and taken a plea of the oral gift. A gift indisputably becomes complete when a person transfers with immediate effect the ownership of his movable or immovable property to another person, and that other person himself or someone else with the consent takes possession of the property gifted. Under Mohammedan law is a contract which takes place through offer and acceptance. The conditions to make a valid gift and complete gift under Mohammedan law are as under. The donor should be sane and major and must be the owner of the property which he is gifting. The thing gifted should be in existence at the time of hiba. If the thing gifted is divisible, it should be separated and made distinct. The thing gifted should be such property to the benefit of which is lawful under the Sharia. The thing gifted should not be accompanied.
One more thing. Wife of a Mohammedan, is she entitled for any inheritance?
Wife, just in
She is entitled.
yes. Wife is
The wife died in 1997.
yes, sir.
Was she residing at the same place?
That I have to I'll take instruction.
ये instructions से तो नहीं होगा ना.
Lordship is asking that wife
Wife of a
is
Mohammedan,
entitled for.
is she entitled for any inheritance of property?
Yes, 1/6.
Because 1/6, right? And here in this case, the wife of the so-called donor expired much after him. She died sometime in
97.
1997.
7.
And entry of this gift is made much prior to that, in the year 1960.
70. Khatian 79.
Where was she residing at that point of time? Was she residing with her son or she was residing somewhere else?
No,
It has not
Lordship,
come
the
to this.
moment if their case is proved that the hiba was correct, then mother also goes.
Yes, mother also goes.
So they don't need to say whether where the mother was, irrespective of the existence of the mother, whether she was alive or not alive, because that was the self-acquired property of the father.
That's right.
So once their case is proved and if they are able to persuade this honorable court that the oral hiba is legal and valid, then those things are immediate. So that won't be and by the time this partition came, the mother also died. So that's why that's basically it's merged.
Much emphasis has been given on the basis of this Khatian Parcha it was done. But this is slightly dicey.
Yes. Divorce this.
Divorce this you have to say.
Yes. I know that. That is one of the grounds. If Lordship could see further, read further, even the judgments which I had quoted has been discussed, because the punch line is in declaration. The first condition of hiba, that you have to declare that you are giving this property to this. Declaration is not a simple declaration, what Mullah says that declaration to the public
It's
at large.
required to be proved.
It has to be first established and pleaded. First plead, then prove, and then establish. The three aspects.
Rest is all follow-up.
Yes, you have to first plead that this was done in the presence of so and so persons. It could be 2, it could be 100. That declaration has to be very vocal, very explicit, because the law is very clear that as the Muslim law, even oral hiba is allowed, which is not to be registered compulsorily and which cannot be registered because it is oral. So therefore, if there is any lacuna and if the case is not proved by a cogent and clinching evidence, then the benefit must go who are being affected by the hiba. So it will not be taken as that some lacuna, because see, the precaution has to be fullest, that once somebody is relying on an oral hiba,
That oral declaration has to be proved,
Proved.
pleaded and proved.
yes, pleaded, proved, and then it should be established that yes, it was done. Because possession aspect, they did not say anything. They were in possession before that also, and rather in order to prove the ingredients of hiba, they said that the possession was handed over.
Mere possession, we cannot move in a backward direction.
No, what I'm trying to
Mere
say,
possession will not prove
it will not go from the reverse.
Yes.
It will not be that
This
it was
is
a possession.
This is your argument.
Yes.
I will read.
No, further that possession is either actual or constructive. Possession is not that important because we have never disputed their possession.
That's it.
They were in possession even before the hiba. But in order to meet the ingredients, they say that they were given possession in 1967.
During
Which they should not have said.
cross-examination, one of the witnesses has stated that the property was given to him for the purposes of business.
Use and occupation, vigilance, everything in evidence it has come, and we have not. But what I'm trying to say that in order to be over ambitious and over zealous, they said that this hiba, after the hiba, the possession was given simultaneously because they wanted to meet the criteria, and they were not knowing that actual possession or physical possession is not necessary in hiba. Even the constructive possession is enough.
That's all.
But they wanted to meet the criteria. Declaration, yes, done. Doni accepted and possession given. So while they were actually in possession from the prior date of the hiba, they should have simply said that as we were actually there in the possession, so the possession was constructively handed over to our exclusion.
Possession will not entail a situation that everybody has to be chucked out of the property.
It is not that you have to first, everybody has to go out. Because in hiba, what happens that if there are 4 sons are living, and if the father gives hiba, does hiba, oral hiba in favor of the one son, and the son in whose favor the hiba is done, he can allow the other brothers to stay.
That's right.
He could be, they all could be staying in the same. So therefore, the possession word is basically either actual or,
That's
but
right.
they cannot say that possession was never handed over. There could be a situation that I never take a possession was adverse to somebody else, but I say that no, hiba was done. There the issue of possession will be there. But in this case, they, in order to be overzealous, try to bid out a case that in 1967 we were given the possession, which they should not have said. If somebody else would have been there in the place, they should have simply said that as they were already staying there, we are having the possession. From the date of the hiba, we became in exclusive possession, exclusion to the all others legal heirs, because the possession was already with us.
But how do you explain the entry in record of right during the lifetime of Abdullah?
Lordship, if I read the entire thing, what is the actual story is?
Because this is also
Yes,
come up.
this property was in Jamshedpur. It has come on record that father used to live in the village in Bihar. All others brothers were living in Bihar. So he was only here in Jamshedpur. That's why the father allowed him to stay and do the occupation. So therefore, whatever he has done at the back of his father as well all other legal heirs. Whether during the life of the father or after the demise of the father. It is not his case that in any of the documents, in any of the records, the consent of father is there. If he would have initiated, the father died in 81. He, while survey or while in the mutation or while even in that holding, while in Mango, that settlement area, the name when was changed, the father would have given the consent. Yes, I have given this property to him. Let the survey, because in evidence it has come that the person who was the donee was the ward commissioner. He managed the entire survey. He got his in his own name. That took 7 and 8 years to get into that. But beholds this all that, whether your name is there in the survey, whether your name is mutated.
That is not conclusive.
Yes.
There are
no
further
finding to that.
ingredients There are for I have selective hearing. Things which are not on record, I don't hear.
Yes, yes.
No, they are saying that he was a ward commissioner, so he managed.
I have seen there is no such finding.
Yes,
so
no
I
such
have
finding.
excluded that
Yes,
part.
dehorse all this. HIPAA has to be proved.
One submission.
Hi.
So far as
Continue.
police-
You finish it. It is just one more page,
Yes.
I suppose. You just finish it. There are slight discussions because questions that crop up and that is required to be clear. These
It
are
is
the
also-
judgments they are referring to. 1966. This is one judgment which we will read ourselves, right? This you have to place. Then another judgment is 2009 SCC Andhra Pradesh, correct? Then one second appeal also decided by this court. Which part you want to read? Kindly read it.
Page number 39, internal page number 39,
Page number
the
39.
ingredients of gift.
Yes.
Subsequently, your issue. It is also well settled that if by reason of valid gift, the thing gifted has gone out of the donor's ownership, the same cannot be revoked. The donor may lawfully make a gift of a property in the possession of a lessee or a mortgage. After effecting a valid gift, the delivery of constructive possession of the property of the donor would serve the purpose. Even gift of a property in possession of a trespasser is permissible in law, provided the donor either obtains and gives possession of the property to the donee or does all that he can do to put within the power of the donee to obtain possession. So far as the oral gift of land concerned, there is no cogent evidence adduced on behalf of the contesting defendants to prove the same. On perusal of Appendix C28 filed by the contesting defendant, which is the correction slip dated 10/11/1987, which shows the mutation is on the basis of Khatiyan Parcha, which falsifies the story of contesting defendant of oral gift.
This is important. The reason why my oral gift is false is on the basis of this correction.
No.
This is
That
the
is
finding
one,
of the
one of the findings.
We will not just pick up one, and as it is, we are in first appeal. We'll see the entire evidence.
On the point of oral gift, learned counsel for plaintiff have relied upon the decision reported in AIR 1966 SC 1194 Maqbul Alam versus Khodaija and taken a plea of oral gift. The question regarding valid oral gift under the Mohammedan law was the subject matter of consideration in the case. Dealing with the facts of the case, the Honorable Supreme Court observed the applicant examined himself as witness in this case. He said that the
Gift was made.
gift was made on 10/2/1943 in the presence of his parents. His mother was alive, but she was not examined as witness. The date of gift was not mentioned in the plaint or in any other document. It is disclosed for the first time in the witness box, and even then, it was not made clear how he remembered the date, the absence of any record. Considering all circumstances, the High Court held that, in our opinion, rightly, the applicant failed to prove the alleged oral gift.
In that case, it was the date was disclosed in the witness box. In our case, it was not disclosed even in the witness box. We are in a better footing.
Another case on the point of oral gift, which has been cited by the plaintiff, 2009 SEC online DT.17.06.2025 Atwal Abdul Hakim sub died by versus Nesam Sufi and others. SA 802 of 2009 decided on December 1, 2009, in which para 13 it has been cited. The second plea raised by the first defendant was that his mother made an oral gift in favor of his father, Abdul Ghafur, and his brother, Ismail and Ghulam Muhammad. The three donees in turn are said to have executed a sale deed exhibit B3 dated 21/1/1970 in his favor. None of the three donees were living by the time the suit came to be filed. The plaintiffs flatly denied the oral gift. In the written statement, it was pleaded that one Mr. Nagasuban, examined by DW2, was present when the oral gift was made. However, in the deposition DW1, the first defendant did not speak about the presence of DW2. In his cross-examination, DW2 stated that the oral gift was made on 18/3/1969, whereas according to the contents of the written statement, it was made on 1st March 1969. There is serious discrepancy as the person in whose favor the oral gift is made to have been made. According to DW2, one of the donors is Saifuddin, the third plaintiff, that is at total variance with the plea of the written statement.
When we have quoted this judgment, Your Lordship, that in their case, DW4, who says that I am son of one of the witnesses, the other DW1, 2, 3 did not name the DW4. So when DW1, 2, 3 could not prove, they brought a person stated to be the son of one of the witness. Even the son did not say that my father is alive or died. Even the son did not say that. And he writes in examination and so, I am so and so, son of so and so. He doesn't say late. The other witness says that I am son of late so and so.
So the same person should have come.
Yes, that might be that the father was hesitant to come to the witness box saying that it is not correct, I won't go. Anyway.
Oral gift is typically a facility which is available exclusively to Muslims in the ordinary course. A gift is required to be made through a registered document as provided for under section 123 of the Transfer of Property Act. When such a vital requirement as to registration is relaxed, the proof in form of oral evidence must be unequivocal and clinching. The benefit of any doubt or contradiction has to be given in favor of the person who is adversely affected in the event of the plea of oral gift being accepted. Any relapse in the regard is likely to provide handle to an individual to trample the rights of the other person to succeed in accordance with law. Therefore, the plea raised by the first defendant regards oral gift was rightly replied by the learned trial court, repelled by the trial court and lower appellate court.
This is what I was quoting.
From the perusal of the above decision, it is found that these both decisions are reliable from the instant suit. It is not disputed between the parties that the common ancestor of party S.K. Abdul Ghani was residing in Bhojpur and S.K. Ghani left home some landed property and a house in village Bhojpur and has not been included in the suit for partition, and it is admitted fact between the parties. PW1 Muhammad Mahfuz Alam in para 35 of his cross-examination has admitted that the time of death of Abdul Ghani about 12 to 13 bighas of land was left, where the agricultural land and house are there. Further, this witness admitted that Muhammad Alam, Moin Alam, Jabbar Alam and all sons of Abdul Ghani had sold a land to PW2 Shakil Ahmad in para 24 of his cross-examination has stated that his grandfather Abdul Ghani was resided at Bhojpur, who was farmer, and he has about 30 to 32 bighas land. Further, in para 25 to 26 of the cross-examination, witness admitted that his father and uncle had also sold land at Bhojpur. PW3 Muhammad Khalid Azaz Hussain in para 29 of his cross-examination has admitted that his maternal grandfather was permanent resident of Bhojpur. They used to do farming but can't say how much land were used for cultivation. They have not got any share of Bhojpur land. DW1 in para 19 of cross-examination has stated that both parties are legal heirs of Abdul Ghani and disputed land has not yet been divided amongst DW2. In para 18 of the cross-examination has stated that thereafter the death of Abdul Ghani, disputed land has not been divided. DW3 is para 41 of his cross-examination has stated that Abdul Ghani property has not been divided here. From
We must explain that they had taken one objection and they moved an application also under 617 that there are other properties also. So in partition all the properties should be joined, even including the properties in the village Bhojpur in Bihar. That application was dismissed by the learned trial court by an order which I will show. They came to the High Court challenging that, but we withdrew that. So that attained finality. So there one of the points was that you have to include all the properties like we include in Hindu law. But in Muslim law, it is not compulsory. The mullah says that partial partition is allowed. Basically, all the legal heirs are the tenants in common. They can claim in one property, they might not claim in another property. So the joinder of properties, they had taken the plea before the trial court. There are two aspects to it. One is that the
Joinder
application was dismissed, which they challenged in the High Court, withdrew it. In any case, on the legal aspect, it is not necessary that all the properties which I am entitled for the share, I must include when I'm asking for a partition or my share. I'm asking for the assertment of my share. I'm not a co-partner like a Hindu. I'm not a joint owner.
Under the Hindu law, the entire
I cannot
property-
leave. Entire property has to
Partial
be.
partition is not permissible.
It is not partial. That is the mullah, and I have given the judgment also. And the mullah says so. Doctrine of partial partition applies on Hindu, not on Muslims, because we are not co-partners. We are not joint owners. We are tenants in common. So we can have our rights in one property. We might not have right. We say that we don't want that. We might continue living jointly or living together. So in that context, these evidences and all that, but this is all irrelevant to the.
Your Lordship, one relevance will be there, Your Lordship. That will be to the extent that the other properties of Abdul Ghani
That's all.
has been sold by the co-sharers, and the defendants herein have not claimed any part. There has been 30 to 35 bighas of land in Bihar. So these defendants have not taken any share.
So they have to take their own case.
Merely because
So this fact has come.
merely because one of the person has acquired the property through hiba, does it disentitle him to claim partition in rest of the properties?
No.
So,
That
so,
directly-
so then you go and challenge the sale deed.
Yes,
You ask for the money.
There is no exclusion by virtue of hiba.
It can't be an exchange that yes, we have taken in Hiba, you take it in village. It can't be an exchange.
But
So as they
the
did not
fact
get any
remains, Your
share, you
Lordship,
must get
that
not.
other properties have not been
You might be
interfered by
having
the
your rights there. You
other
challenge that,
properties
you
have
take your
not been
rights.
interfered with by the defendants.
That's
The
right.
applicants. From perusal of exhibit,
Yes, we have seen that.
These are not relevant.
No
That's why I
previous
said it's not
partition.
relevant.
The issue number 5. What is the finding? Who died when? Safia died when?
Safia died
Before
predeceased
that.
father.
You see,
Predeceased father.
DW3, just a moment. DW3, your witness,
Has
in
admitted.
his cross-examination, has stated and admitted that Safia Khatun died before the death of Abdul
Grandfather.
Ghani.
They were taking different
Right.
names, Safia, Satya, but the only one daughter was there who predeceased. He admitted that.
So,
So that issue
stood
goes.
admitted. So, non-joinder goes.
It's not it.
Now, only the hiba.
That's the center point.
अब बताइए
that remains.
कब करना 4:30 बजे आपको पूरा कर ही लिया अब क्या बचा आप इसी में हाँ
And he did it so well.
हाँ yes you have done it very well
He has been engaged already.
that's right he has already been engaged he
Yes,
has already been engaged तो कल कर लेते हैं फिर क्या
as your lordship.
आप रहेंगे
I'll be. I'm bound to be here.
Your lordship,
I want to finish and go to vacation, which I'm waiting. So, despite the fact that I have a ticket, I will get it cancelled because this is more important for me to finish and then to
मेरे
oblige my
चलते
wife
आपको
to go
एक
for
ticket cancel
vacation.
कराना पड़ा
No issue that. These are part and parcel. Right? Because this is more important. The court is giving indulgence for to finish this matter, hearing patiently. I will be the most happiest person to continue.
you can also prepare a note
in that case, day after.
नहीं नहीं नहीं
Then I will be in start.
पूरा पढ़िए
I'm not-
पूरा जजमेंट फुल टेक्स्ट पढ़िए
Yes.
ठीक है अब आपको सिर्फ ओरल एविडेंस देखना है और वो जो ओरल एविडेंस में आपका क्या आया है व्हाट ऑल आर द विटनेसेस व्हाट इज द कॉन्सिक्वेंस ऑफ नॉट एग्जामिनिंग द विटनेसेस एंड व्हाट इज द कॉन्सिक्वेंस ऑफ नॉट डिस्क्लोजिंग द डेट ऑफ हिबा इज समथिंग व्हिच इज रिक्वायर्ड टू बी कंसिडर्ड राइट इज इट फेटल टू हिबा or still the hiba will sustain only because of the reason that they have said that there was oral hiba and this was followed by exclusive partition as per your case.
At 2:15 your lordship.
Tomorrow at 2:15.
I was just.
वो करिए ना कंटिन्यूटी में क्योंकि पता है 2-3 फर्स्ट अपील के फाइल खुल जाते हैं तो बहुत ज़्यादा दिक्कत होती है एक का फैक्ट दूसरे के साथ मिक्स होने लगता है ठीक है
Gotcha.
FA number 15 of 2025. Learned counsel for the appellant, counsel for the parties are present, kindly give your appearances. The learned counsel for the appellant has commenced the hearing. He has submitted that the facts stated, the case of the respective parties stated in the impugned judgment does not suffer from any omission. And the facts can be taken from the impugned judgment so far as their respective pleadings are concerned. During the course of hearing, it transpired that essentially the parties would join issue before this court with regard to non-joinder of Safia Khatun, of the legal years of Safia Khatun in the suit, and also with regard to legality and validity of hiba, within bracket oral gift. The plaintiff were seeking partition of Schedule B property, and defendant number 1 claimed that the property was given to defendant number 1 through hiba, and there were sufficient materials on record to show his exclusive possession. The hearing has remained inconclusive today. Post this case for further
The
hearing.
matter is part heard.
Yes, of course, it's partnered. It will be taken up at first case.
May record as part heard because it will remain as part heard.
Yes, कल खत्म हो जाएगा. Let this matter be treated as partnered.
Lordship, that aspect of legal year of Safia has, I think, he has conceded. So there is
Concession देखिए,
Anything.
senior के absence में concession record करना ठीक नहीं है. And we will see.
Even in that aspect, the law is clear that even if any one of the legal heirs in Muslim law, unless she is in possession, is not made a party, the suit will not be dismissed. That is also a law. So that is a last resort to me if they are able to show that. The law is very clear on that. I am only entitled to, if I am seeking my share in a particular property,
You are entitled to the extent of your share. But
Yes.
her share will not be earmarked, no?
it will not
She
be.
is not there.
So the only difference will be,
proportion.
proportion. That instead of 12, it will be 13.
That's
So that will be very different. But
Insignificant.
suit will not go. That is for sure because in Muslim law it is allowed. The only thing that if somebody who is residing in a property in which you are seeking your share, then you have to make that legal heir as a party.
Okay.
Because I am not disturbing anybody's.
Certain orders cases are there. Is there any urgent matter? आपका कुछ है urgent ऐसा?
Limitation.
Serial number 7. कितना डिले है आपका?
187 days.
Serial number 7 का फाइल लीजिए. FA number 86 of 2024. Counsel for the appellant is present. He submits that the petition is barred by limitation by 186 days. And a petition for condonation of delay has been filed by RA number 7143 of 2025. Less notice we issued to the respondents in the main appeal as well as in the interlocutory application seeking condonation of delay for which requisites we filed. Requisites under speed post be filed before this court within a period of 1 week. Office to track speed post delivery. एक बात बताइए, ये नाम बहुत सुना हुआ लग रहा है, इसका कोई क्रॉस अपील भी फाइल हुआ है क्या?
जानकारी तो नहीं है.
पता करिए भाई, क्योंकि हमको ध्यान आ रहा है कि इसका वेरी appearing in that case क्रॉस अपील. उसके बाद एक डेट दे दीजिए अवेटिंग सर्विस, दोनों में करेंगे, ठीक है? Records, let the records be called for. Sorry? ऐसे नहीं, टाइम बार्ड केस में एग्जीक्यूशन स्टे नहीं होता. बताइए और क्या है?
Serial number 6 because on the last occasion we have taken some time to file a substitution because certain respondents because they have expired. Because the concerned appellant because that she has fractured her leg because.
You need time?
Yes, because.
Serial number 6. Counsel for the appellant seeks adjournment. Post on 31st July. Next.
Like,
कौन सा है इसको? आपका कोई मैटर है? बताइए किसका जो मैटर है, नहीं तो अदरवाइज ऑर्डर्स में कुछ.
Serial number 4.
Yes.
Service notices were issued, and since 2 last office notes and service report for the respondent ID declared not received. Do I have been filed?
Post on 31st July awaiting service report.
Yes.
of respondent number 19. That's all. The minutes. और कोई है? हो गया? और बताइए? आप और कोई है इसमें? Nobody? इसमें कोई देख लेते हैं.